Welcome to the News at 6. I'm Hunter Funk. Idaho's near-total abortion ban is now being challenged by a local health system. St. Luke says the ban is putting their providers in a difficult situation where they can't comply with both the state law and the federal medical care requirements during some emergency situations. RJ Binkley spoke with St. Luke's about why they filed a complaint in the lawsuit. Jude?
Well, Hunter, the U.S. Department of Justice filed this lawsuit against Idaho in 2022, but St. Luke's is anticipating that challenge could go away with the new presidential administration. Now, currently, there's an injunction to allow an abortion in an emergency situation. The health system wants to see that continue. With a looming change in the nation's top administration, St. Luke's health system is trying to make sure a lawsuit against Idaho's abortion ban and the preliminary injunction partially blocking it don't go away.
The next administration has made it pretty clear that it does not intend to protect reproductive health care at the federal level. So we expect that it will not continue its challenge of state abortion laws.
St. Luke's filed a complaint and a motion for injunction relief for the U.S. versus Idaho lawsuit that alleges Idaho's ban violates the Federal Emergency Medical Treatment and Labor Act, or EMTALA. EMTALA requires patients receive necessary emergency medical care even when the only treatment to stabilize a woman's condition is to terminate a pregnancy.
They would do so to protect that woman's health.
The lawsuit claims Idaho's law currently doesn't allow that unless the doctor can prove an abortion would prevent the mother's death. Peg Doherty, deputy counsel for St. Luke's Health System, says physicians are caught between state laws that can limit care and federal requirements to provide emergency medical treatment, a conflict that could put both doctors and patients at risk.
In those cases where their condition poses a jeopardy to their health, short of death, providers are left in this tough spot where they can either comply with EMTALA and offer the termination of pregnancy to protect their health, or they have to make a decision that would they be performing an abortion to prevent this patient's death?
Idaho Attorney General Raul Labrador released a statement responding to the move, saying in part, the U.S. Supreme Court has already ruled that the Constitution does not contain a right to abortion and that laws protecting the sanctity of life are left up to the individual states. There is no conflict between the plain interpretation of Idaho's Defense of Life Act and EMTALA. Idaho law protects both the life of the mother and their unborn child. St. Luke says without the EMTALA protections, they'd have to offer alternative options to patients having medical emergencies, which is often sending them somewhere else for care. There was a period of time in early 2024 when the injunction wasn't in place, when they had to send patients to other states.
The providers, after consulting with their patient and explaining what was happening with the patient and the limitations on what they could do, the patients made decisions to transfer out of states where they could get the full spectrum of care. In all of these cases, we are talking about wanted pregnancies, really desperately wanted pregnancies. And it is truly a traumatic situation for the pregnant woman and her partner.
And Doherty says they would ultimately like to see the court rule that EMTALA preempts state law. Hunter?
Yeah, tough situation to be in. Thank you, Jude.